It's a jam-packed program, and it couldn't be more exciting. My name is Greg Peterson. I am the president of the Robert H. Jackson Center, and I'm thrilled at the attendance for the anatomy of the Buffalo Sabres acquisition. The genesis of this particular CLE will become clear as the day goes on. Suffice it to say, you'll see references to Allegheny College, you'll see references to a fraternity down at Allegheny College, and you'll note some of the dots that are connected throughout today. Obviously, the highlight of which is the presentation and Ted Black, President, CEO of the Buffalo Sabres, and we're thrilled that this is our opportunity down here in this part of the state to hug the Sabres and the new ownership of Terry Pegula. This event does not happen, absolutely does not happen without all of the sponsors, and you see many of them here represented. And let me go through them very quickly, and if you could raise your hand when I call your name. And if I miss your name, I apologize, because we'll certainly, if you hear your corporate name and I don't recognize you, just raise your hand anyways. Go crazy. Chautauqua Abstract Company, John Ordendahl. The Chautauqua Region Community Foundation, Randy Sweeney, Lisa Lynn, Joel Kiefer, among others. The County of Chautauqua Industrial Development Agency, Bill Daly and Rich Dixon. Five Star Bank, Steve Swanson and Tim Dole. The most important person, especially for you lawyers here, Phillips Lytles, Mary Parsons, who is right over there. Please do not forget to fill out these things when the day is done. Gerard German and Kelly, they are the law firm in Pittsburgh who is providing David Lowe and Eric Springer, who will be here shortly. The Robert Jackson Center with Megan Sorensen and Carol Drake, and Carol Drake, and Carol Drake, she said. DFT Communications and the Matum Company, Ellen DeTanto and Jeremy Ward. Manning and Napier and the Exeter Trust Company, Veronica Van Nest. BWB, John Lloyd and Bob Gunderson. The Cattaraugus County Bar Association. The Center for Rural Regional Advancement at SUNY Fredonia, Chuck Cornell, if Chuck's here. The Chautauqua Sports Hall of Fame, we just pause there. When you go downstairs for lunch, there will be a table, and a table will have pictures of Danny Gear. Danny will be signing them if you're interested. The Game Time Sports Bar and Grill, the Greater Chautauqua Region Estate Planning Council, Cameron Brooks and Steve Wright. The Heritage Group, Sandy Algren and Doug Justum. Holt Associates, Pete Holt. Hometown Grill, IDS Virtual Depot, Sato, is here, Sato? In-Hand Sam Process Service, Bruce and Marge Kinney. By the way, they have an interesting GPS program. They can actually track down the process servers and you as well. Jamestown Bar Association, the Jamestown Business College, the Legend Group, Lewis & Lewis, George Panna Bianco, Merritt Estate Winery, which, by the way, has a great basket of Pat LaFontaine stuff. The Northern Chautauqua Community Foundation, Diane Hannum and Ida Klon. The Northern Chautauqua County Bar Association, the Resource Center, the lovely Vicki Bardo right here. Roe Henderson Insurance Agency, the Robert H. Jackson Center, Inns of Court. Cindy Rogers of the Rogers Land Surveying. UBS Hamlin Bank, Todd Natishan, Craig Hart, and Tim Edberg over there. The Vineyard Group. And our luncheon sponsors, the Allegheny College. You see this here because you will note that there are many folks who are in our panel today from Allegheny College. And the Blakey law firm, Byron Blakey, who is also from Allegheny College, and we have stories on him as well. Let's give them all a hand. This is amazing. This event requires a lot of planning, a lot of help from an awful lot of individuals and sponsors, and we're just absolutely thrilled of what will happen over the next few hours. But I think it's appropriate at this time, since the subject matter is the anatomy of the Buffalo Sabres acquisition, that we sort of pretend that we really are at the First Niagara Arena. And if you folks can kind of spread away from the screen at this moment, we're going to ask everybody to rise for the National Anthem. we hope. And now, to bring you the play-by-play of today's event is not Rick Jenneret, but the closest thing we could get, Randy Sweeney.
I come a little cheaper than Rick Jenneret. Good morning, everyone. I'm Randy Sweeney, Executive Director of the Chautauqua Region Community Foundation. A few housekeeping items before we start, just in case, and we don't plan on taking advantage of these exits, but we do have one here. There's one at the top of the stairs, and obviously the main exit that you entered by. And if this is your first visit to the Jackson Center, there are restrooms right out the door and to the left. Keep in mind today, when you're downstairs, look for the fish bowl that you'll want to put your business cards in. There'll be some prizes given away later in the event. And as Greg mentioned, make sure that you find Mary Parsons, on your way out. Our program for today, we're going to begin with a 2-hour session. We will have 4 presenters during that 2-hour time frame. Each one will have approximately 30 minutes each. We'll take a break about quarter to 10, or quarter to 11, and come back in about 15 minutes at 11 o'clock, and then we'll introduce our speakers for that time slot. Obviously today, as Greg has already indicated, we have a number from Allegheny College. As he also mentioned, they have provided our lunch today, and also the lunch is sponsored by the Blakey Law Firm. I will go ahead now and introduce the 4 speakers for this first segment, and we'll let each of those segue from one to the other. Our first presenter this morning is Gregory Edwards. He will be speaking on various issues around economic development. We all know Greg as our Chautauqua County executive. He's reduced property tax rates since he has been in office and increased the county's bond rating to an A+, and spearheaded several creative economic development initiatives to produce additional revenue. Greg graduated from Allegheny College and the University of Toledo School of Law in 1986 and has spent over 18 years as a private practice attorney. The next presenter after Greg will be George Panna Bianco. George will be speaking on workers' compensation. Mr. Panna Bianco is also a graduate of Allegheny College and currently acting city court judge here in the city of Jamestown. Mr. Panna Bianco views an injured worker or an accident victim as a person with special needs, which he tries to provide. His focus is always on the client. His goal is to always be responsible, productive, and he's involved in a number of community activities, most recently a very successful Lucy Desi 100th birthday celebration. The next presenter will be Byron Blakey. He will be speaking on intellectual property. He's the founder and managing shareholder of the Blakey Law Firm. Mr. Blakey, also a graduate of Allegheny College, has 20 years of experience, which includes trials and appeals involving patents, trademarks, trade secrets, false advertising, and unfair competition. In addition to litigation, Mr. Blakey has done extensive work in IP due diligence and licensing. The last presenter in this first segment will be the Honorable Stephen Cass. He will be giving us an update on issues in the surrogate court. Judge Cass works in the Integrated Domestic Violence Court and is the Chautauqua County Surrogates Court Judge. He graduated from Allegheny College with a law degree from Albany Law School. He is the former president of the New York State Surrogates Association and is active in many community civic organizations. Each of the presenters said they might stray from the topic a little bit, as apparently there are a few stories they'd like to share with you this morning. So, Greg, would you lead us off? Thank you. Unfortunately, I wish I had graduated from Allegheny College.
I'm glad to see that Bruce has started the heckling early so that we're all prepared. I'm going to adjust this mic just a little bit. I don't want to overwhelm the audience with volume here. So everybody in the back row, can everybody hear okay? Somebody give me a high sign if it gets a little bit loud, because I sometimes get passionate about what I truly believe in, and I truly believe in the great education I got at Allegheny College, so I get excited about that. I get very excited about my co-presenters and lifelong friends that I generated down there. And I also get very excited about Chautauqua County. And so if it gets a little loud, raise your hand, give me a high sign, whistle from the back row there, Bruce. I'll take it as encouragement if you did that. I want to start by making an observation that I think we probably all of us as professionals, but particularly those of us as lawyers, recognize that these continuing legal education programs don't come together easily, and they take some significant planning. And I'll just share an observation of a non-lawyer, and that was my sister was here. She was recruited, as many people have been, by Greg to be a sponsor, and appropriately so, of these events. And so she came here for the Woodstock and the First Amendment CLE. I wasn't able to make it that time. I was out of town that day. But I caught her afterwards, and I said, Brenda, how did that CLE go? She goes, Greg, I don't believe it. She said, we in the insurance practice, she has the J. Edwards Insurance Agency insurance company. She said, in the insurance business, we have to travel to Buffalo. We have to spend hundreds of dollars to get our continuing education credits done. We have to buy our own lunch. You guys got this lined up. You come here for free. You get a free lunch. You get a free T-shirt, and you get all of us to pay for it. So I think all of us probably should join together and thank Greg, the law firm of Phillips Lytle, the Jackson Center, all those who put this together for us for free, and hopefully it'll provide some significant value as well. I did have the pleasure of growing up here in Chautauqua County and spending 4 years at Allegheny College. And those of you who know Allegheny College, I won't belabor the point, but it's truly a liberal arts college that really forces you to expand your horizon and expand your understanding of the world, to be introduced to things that you otherwise wouldn't have been, by forcing you out of what might be a pigeonhole of one focused arena into a variety of things. And it also gives you a chance to meet some wonderful folks. And we'll brag a little bit today, but really I won't belabor that. We have all sworn vows of secrecy. That's part of the obligation to get a diploma from Allegheny College. You have to, prior to accepting it, sign an oath that prevents you from relaying anything of any intimate nature with regard to any decision you might have made during those 4 years that would cause you some concern later in life. So I'm trusting the rest of the guys will follow suit. Not that any of us have anything that we would ever not want to relive, but I am thrilled to be here. I'm thrilled to be your county executive, and I'll tell you that one of the things that has been most enjoyable about my role, despite its significant challenges, and I need to update my bio there because we did have to raise the property tax rate last year and this year, is the fact that we have been successful in Chautauqua County, growing the opportunities for you as attorneys to represent your clients in business deals, and in doing so, improve your client's business and hopefully improve your bottom line. And what I want to do is walk through the anatomy of a couple of these deals to give you some encouragement that there's opportunities for you as attorneys to get engaged early in business deals, to connect better with your clients, solidify that relationship, and let's face it, make some more money. And I think that is the bottom line here, is that you have to be successful, your clients have to be successful, and together everyone in Chautauqua County ends up being successful. So the title of my presentation this morning is going to be How Chautauqua County Can Be Your Partner to Make More of Your Clients' Deals Happen and Make You More Money. And again, I think that's an important thing for us to understand, that all parties to these deals have to be engaged, they have to know what they're doing, and they have to be focused on getting the deal done. The teaser I'll give you is that by working with the business professionals that we've assembled in Chautauqua County on the economic development side, and believe me, they are professionals. And while I knew that when I recruited them, it's been confirmed over the last 4 or 5 years that they know how to close the deals, and they know how to work on challenging deals to get those done. And working with them, you as attorneys and other business professionals can gain particular access to more capital. You can eliminate the procedural delays that I think are sometimes inherent in government operations, because what you're going to have to do to be successful is you're going to have to navigate local, that's village, town, city, county, municipalities. You're going to have to coordinate and sometimes negotiate with the state at the state level, and you also have to deal with federal regulations and the challenges that sometimes present themselves there. And by doing that, we can partner with you at the county to bring those deals together. We can also introduce you to a broader range of partners to get your deals put together. And I think if you may have developed the opinion in the past that Chautauqua County can be a barrier to deals and making these deals happen, I think the business closings that we had that we'll identify should prove that wrong in and of themselves. But I'd encourage you to talk to some of the local lawyers who represented some of these individuals, because nothing is better than to talk to somebody who has been involved in your role as an attorney in these deals and get their opinion as to how these things come together. Now, being in a room full of lawyers and business professionals, I would expect you to be thinking, great, sure, anybody can tell you anything, but really it's the performance that matters. And that's why I'm going to focus on 3 of these deals. And I'll just highlight the 3 of them, and then you'll see there the nature of the variety of the deals, and then we'll talk about some of the complexities and the roles that Chautauqua County played. The first, and I think one of the most significant deals that's been closed in Chautauqua County in many years, and I'll let those of you who've been around for a while determine how important this was the Skf deal. And I'll walk through that in some detail. It's an $18 million deal involving over 600 employees. And I think when we get all done, you'll realize that the county had a major role to play in that, and a unique role to play in it, in the nature of the deal. The next one's going to be the Remtronics and Exelco Newbrook deal. And that's unique in that we had to coordinate with a local municipality to basically relinquish a claim they had to a business and its jobs and share it with a neighboring municipality, and then the county had to take a risk position in the middle of it. So that then the property could be redeveloped, a piece of the property could be redeveloped, so that other opportunities could be created from that. And I think that's an important role that Chautauqua County can play in the right deal, is to assume some of the risk in a transition time frame. The last deal is a significant one that we'll talk about, and that was a real forward-thinking decision on behalf of my economic development professionals, and a significant risk of it wasn't a $5 million risk, but it was an acquisition that had significant downside. And the county had to step in and take that role, and as it turned out, in doing so, preserved one of our excellent businesses and 147 jobs in doing that. And I think that's going to be another eye-opener, I believe, because so many these things happen, and I know from being in your shoes, your nose is pressed against the grindstone. You're trying to get that next deal done. You're trying to close that next real estate transaction. You're trying to acquire that next partnership agreement for the next client, manage your own individual businesses and the employees that you're required to manage, pay your bills, cover those costs, and really be an entrepreneur. And the chance for you to step back and look at bigger deals or the horizon where these deals are taking place is very limited. So I will hope that this brief conversation we're going to have will give you an opportunity to step back and realize that some of these deals have been happening and why they can benefit you. The last thing we'll talk about are some of the details, because let's face it, money is key, and if you can access better dollars, less expensive dollars, in some cases, or many cases, larger quantities of dollars to close your clients' deals, that's what's really going to bring that all together. And so I'm encouraged, and Joel, you're going to help me walk through the slides here, and they're all contained in your packet you can take away with you, but we'll just walk through them. SKF Aero Engine North America. And I will confess, while I knew that MRC, as it was called at the time, was a major employer and did a good job as far as developing opportunities just outside the city in the town of Ellicott, I had no idea of its complexity or any real understanding of its international impact when it came to business and opportunities in the aerospace operations. I also did not realize that it had a major role in our futures going forward, and that this is the international headquarters of their aero engine division. To give you an idea, as you all know, and most people don't, is these deals take time, the bigger ones. From the time they begin talking about them in the boardrooms and in leadership roles in these major international corporations to delivery. But you'll see that in March of 2006 is when the county first became aware that there was discussions taking place at SKF that could have major ramifications. Why do I say major ramifications? Because there's over 657 jobs tied to that single operation right here in Chautauqua County. And not only are they 657 jobs, they're very well-paying jobs, career jobs, and I'm sure that you have clients and know folks that have worked down there for a while. But you can see in March of 2006 was the first time we became aware of some decisions being made at SKF. And that really began with the director of their business units inquiring about grants for new equipment. And that's where I'll just pause just for a moment and describe for you how you can become a much more valuable asset to your clients. When we get all done today, and many of you already know this, but some of you will learn of some of the assets we have to bring to these deals. The sooner, and if there can be one takeaway from this conversation we'll have here, if there's anything you take away with you for your clients, the sooner you can connect with the county, the sooner you can coordinate with your clients to make you an integral role of the plan and thereby give us the opportunity to do that, the better off you're going to be. Because we found out in March of 2006, they're talking about grants for new equipment. And that was all transpiring at the same time we were fighting here locally to keep the Jamestown operation, because equipment was being moved to North Carolina. Discussions were being made about transferring this whole operation outside of Western New York, outside of Chautauqua County. And this was our first opportunity as a county to really step in, because it's sometimes challenging for us to step into a deal if we're not invited. And in this particular case, our invitation to begin talking about this was when they were moving equipment from Jamestown to Faulkner in a transition, trying to consolidate their operations, and at the same time contemplating moving all of it to South Carolina. We met with them. We connected the leadership of SKF with Empire State Development, and we're very fortunate here in Western New York to have very talented people in the roles of the state of the ESD. We put the two of them together so they could begin talking at a higher level about what the state could bring to that deal, and we were successful primarily because we had a local Jamestown guy who was in a leadership position in this equipment transfer. And while he was being directed to move equipment out of Jamestown into South Carolina, he was, I guess in retrospect, making some independent decisions about moving some of this equipment to Faulkner instead. And in the end, that played a significant role for us. 3 months later, SKF put their budget together. And here's another spot where having local players, a community that's involved together in keeping a growing business paid off, because you'll see that SKF wanted a different office space than what they had. And their decision was downtown Jamestown or Philadelphia, Pennsylvania. And you know, when decisions are removed from your community, it's much more likely that those decisions are made to move even more. I want to thank Ray Fisciano personally. And when you get a chance to see Ray, you can thank him and yourselves, because Ray Fisciano played a critical role at this juncture. Because as you recall, Jamestown Public Schools had a nice office suite right there in the Windstream building, the old Alltech building, just around the corner. And as Bill Daly and the other team of economic development folks were scouring the city, trying to find just the right office suite, the right size, the right location, the right price point for SKF in this major decision of where their corporate offices were going to be, they approached Ray at the Jamestown Public Schools and identified that they had in their plans the move that they consummated here across the road, but it wasn't quite ready yet. And thanks to Ray and the team at Jamestown Public Schools, they moved much earlier than they planned, and it cost them, I'm sure, disruption in their operations, and could have cost them some money as well. But they were persuaded by the importance of locking in this leadership right here in the city of Jamestown, and we were able to make a intermediary role there, bring these two parties together, and then work regularly to make that deal come together. They moved out. It was an Empire Zone transaction, enabled us to sweeten the pot a little bit to get them to locate their office there in the Windstream building, and they got that done. You'll see as we go down to the next slide, there's a number of other things that were happening all along the way, but it wasn't until a year later, 2 years later, in February 2008, that SKF actually came out and said what they were proposing to do. And that was a brand new, state-of-the-art heat treat facility. And at that moment, we were in competition not only with South Carolina, Virginia, we were also in direct competition with the Far East, because of the incentives that were being bandied around. And those of you who've been involved in deals, particularly with southern states, you know how aggressive they can be. And SKF, good business people they were, negotiating the best deal they could, regularly reminded us of the things that South Carolina and Virginia were willing to offer to acquire their, think about this, 687 jobs, an $18 million investment just in the heat treat, much less the other investments they were willing to do. But we were committed, and so was the local leadership of SKF, to trying to find a way to get a commitment, because it really was a stake in the ground. Where this heat treat plant was where the next 20 years of growth and development was going to go for SKF. So you'll see in the following slides that much work is taking place, and we brought some more collective local energy to this deal. We brought in the BPU, and I know there's been a lot of conversation in the press over the last few years about the value of the BPU, and should we have an energy plant or should we not have an energy plant. This is an area where it was critical to the success and really the economic future of the region, because the local BPU came together with the New York State Power Authority, negotiating excellent rates in electricity for this development and the obvious need for that in the heat treat plant. And so that was yet another local involvement that played a significant role there. One of the things that I think that was interesting about this deal was SKF was moving forward with their development plans. They're going to build a new facility. They're going to install this new line but they didn't want to own the property. They didn't want to own the building. And once again, we were able to play a role in that because they were seeking out a local developer to help them develop this process because they didn't want to own it, they wanted to lease it. And that is something that we found in both of the Swedish deals we've put together, that is a corporate philosophy they have. They want a small footprint. They also want to have a very carbon neutral footprint. And with the NIPA power and the role they played there, that helped us on both those deals with their carbon footprint. We worked with the local developer, acquired the property, and the developer acquired the property that they wanted to develop on, and we thought we were pretty solid. And you guys and gals have all been involved in these deals. Just when you think you got them pretty well grooved, you're pretty well locked in, business being business, used an opportunity to bring some significant leverage to this deal. So you'll see on this next slide in July, we were back in the hot seat. SKF said, well, we're not really sure. That's where we're going to go. Sweden's telling us maybe that isn't the deal for us. We've gotten some more solicitations from South Carolina and Virginia, and we've hired a real estate company in Philadelphia to really evaluate whether this deal is really what we want to go. And we've all been there, and you don't like to find yourself there where you think you're all in. You've got all the leverage, you've got all the deal put together, you think you are where you want to be, and these numbers get squeezed once again. Going to the next slide, you'll see that we brought together another offer. We sharpened our pencil, and we brought a pilot, a payment in lieu of taxes deal to the table because we were trying to lock in their commitment, and that's really the key. We needed to lock in that deal, get it put together. And the next slide you'll see not only do we bring a pilot together with that, we went back out to our statewide elected officials. They brought significant leverage to the deal. And not only were we able to obtain 2 more megawatts of hydropower, right priced, and again, right for their carbon footprint. And again, these 2 Swedish companies we worked with, SKF and Titan X, are both committed to as carbon neutral position as they could get. That made a significant deal. And the final piece to the puzzle was Senator Young and Assemblyman Parmet were able to get back into Albany, roll up their sleeves, and carve out $250,000 each to bring that to the table at that last piece to close that deal. So what we were able to do, partner with local folks, local professionals, bring the right people to the conversation, and close the deal. As you'll see, it wasn't until August 10th. So we had 4 years in the works on this deal. At any moment, as you know how these deals go, wondering whether it was going to be accomplished. But it wasn't until August of 2010 we were actually able to get the president, international president of SKF here in Chautauqua County, where we had a groundbreaking ceremony. And of course, all those pieces were put together, the I's dotted and T's crossed, because that president wasn't coming out of Sweden until it was done. But you can see a multi-year process that the county was involved in, and we really, I think, provided some of the glue to that deal to make it all come together. So, who were the players? And here's, for those of you following the dollars, you'll see that one of the players was the Chautauqua County Industrial Development Agency. And what they brought to the table was a 15-year tax lease pilot. Business needs security. They need to understand what their ROI is going to be. This 15-year pilot enabled them to know what their tax obligation was going to be over the 15 years. We were able to freeze and then build in increases in their commitment on their property taxes, and that was good. We had an Alltech loan. We'll talk more about that. That's a local loan fund of $12 million that we have right here in Chautauqua County. We were able to bring $1 million to the table there at 4% on a 20-year loan on a payout. That was helpful to them. They knew exactly what their costs were going to be. We were also able to abate the sales tax on construction materials. You can imagine how significant that is on an $18 million construction project. A significant portion of it was the equipment, but they also had to build the facility to house the equipment, and that also added to the deal. And those of us that did this, you know that there's always a tax on those mortgage recording documents, and the IDA through the county was able to abate that, so that was one more incentive for them to get that done. Empire State Development was the next list here. They brought a grant of $1.375 million. as well as another 1.375 million to the deal. New York State Power Authority, they brought 2 megawatts of hydropower. And then you can see the next slide is that our state senator and assemblyman secured some significant dollars to make this deal happen. The Jamestown Board of Public Utilities, they built out the infrastructure so that this could happen. So they were investing in the future. And then you can see just a series of slides here of how they finally came together as far as the building itself. And I'm pleased to say that I didn't have in that slide, and I need to make a point of it, that our union employees here in the county played a major role. The UAW came to the negotiating table, they bargained with SKF, they made significant modifications in their work rules. They needed to have some flexibility on who was working where and what machines they were working at, and I'm pleased to say that in Chautauqua County we have the capacity to get that done because everybody recognizes the value of this deal, and the UAW did as well, and we spent a lot of time recognizing that because I think that's an important component. The next deal is Remtronics, Exelco Newbrook, and a little different deal. Remtronics, a local manufacturer owned by a gentleman out of Ohio. He was currently, or at the time, their business consisted of a 2-story older wooden structure with the same tongue and groove wood floors that we have through so many of our operations, and they're having to move their assembly of their parts up and down 2 floors and through a maze of rooms to complete their processes. And they basically came to Chautauqua County, and they connected with Bill Daly and the IDA and said, unless we can change where we're working, I'm moving my business. This is the owner. I moved my business back to Ohio. It's where I live. It's saved the commute in from Cleveland to manage this business, and so we need to find a different location. And who could argue, given the difficulty they were having in making this process work? 60 jobs were at risk in this. And where the county came in and played a major role was not only in the funding stream that you saw in that last deal, but here was an opportunity for the county to take a small risk. And the risk was the following, that the county had to take a lead role in convincing the village of Silver Creek. And those of you that represent municipalities know that this is much more challenging than it sounds. We had to convince the village of Silver Creek that they had to give up an employer and 60 jobs in their village and allow it to be moved outside their village and lose the economic development growth and potentially have a vacant structure right in the core of their village to avoid this business being moved to Ohio. My thanks to Kurt Lindstrom, mayor, and the village council, very bright people. They recognized that they needed to consider this, and they did. And the fortunate part for all of us is that we were able to locate a facility in Dunkirk, in the town of Dunkirk, just down the road from the village of Silver Creek, where these employees could just move their commute from the village of Silver Creek, and many of them lived in and around the Silver Creek area, to Dunkirk. We were able to bring incentives and encouragements on the finance side to the owner to make that happen. And Michael Cadis, the owner, a challenging gentleman in the sense that he talked about driving a hard deal, and Bill has more gray hair, I'm sure, because of it. It was, kind of a nibble and nibble and nibble and a nibble every time as you're trying to get this deal put together. But we did. We got him relocated to a facility that needed to be renovated, and boy, has it been renovated. But it was a single floor location that they got in and invested a great deal of money, not only preserved the 70 jobs, but they've now been increased almost to 80 jobs in this new location. But that left the one condition of the transfer, and that is that the county had to take ownership of this older 2-story wood-floored structure, and we did. And we also had to make a commitment to the village of Silver Creek that we would find a way to make that a viable business and not just a hole in the middle of the village of Silver Creek. And that's really where good local partners come in, because Chris Lansky and Exelco Newbrook, we knew from doing another deal with them right in the village of Silver Creek, and those of you who are familiar with Silver Creek, as you travel up the hill heading towards the 5 and 20 junction, if you look just to the left, you'll see the major expansion they've done in that facility. And we were able to meet with Chris And we knew that he was looking to consolidate some of his upper end or his white-collar workforce. And we were able to make a very good deal with Chris, and he was able to put all of his engineers, all of his marketing and logistics folks into this one building. Well, he is going to be putting them into this building because right now it's being renovated right there in the heart of the village of Silver Creek. And as a result, that is not going to be a hole of a building that eventually has to get torn down. We actually have private sector folks in there renovating it, rejuvenating it, and really adding to that opportunity in the village of Silver Creek as opposed to moving it. So that's a situation where we can not only bring new partners to the deal, we can also take a risk position in the middle of these deals to try and help these transactions take place. The last specific deal we'll talk about is the Cisco Maple Vale Foods deal. Those of you who've grown up around here know that Cisco had a major operation where Flickinger's really got its start, right down there on Allen Street. And Cisco and its corporate headquarters decided that they were going to consolidate their operations. They were no longer going to be distributing food and food products out of Jamestown. And no announcement to anybody other than we're closing and we're out. A significant shock to the employees there and a real loss for Chautauqua County. We got involved in that as quickly as we learned about it. There was nothing we could do, I don't believe, even looking back in it, to save that. That was a decision, and probably a right one for corporate, to merge those operations and consolidate this distribution facility into the Pittsburgh area facility, saving them tremendous money. It was a hardship to the employees and certainly left us at risk there on Allen Street. But having been involved with businesses, having business professionals working for us at the county, we engaged Cisco, trying to find ways that we could be helpful. And one of the ways they described we could be helpful is buying that building. And those you might wonder, Bill, how many square feet was that again? 300? I was just saying 330, but 300,000 square feet of a distribution warehouse facility. And they said, sure, you can take this facility off our hands for us. And we obviously didn't really have a whole heck of a lot of interest in that until we began working with them and describing and to find a way for that to be helpful. And also, if there's a way for us to leverage that transition and grow jobs, we wanted to do that. Long story short, we were able to provide a significant tax savings for Cisco by the county acquiring that business at a significantly discounted price off fair market value. They got a chance to write off that loss on the deal, and we got a building. Well, that's where Chautauqua County stepped out a little ways because Bill and his team came to myself and Darren Schulz, our finance director, and put together a very solid business case why the county ought to go into the real estate business on the short term, and that why we ought to be a financer of the IDA purchasing this building and then doing the interim maintenance to the facility while it was being marketed. That was a significant risk, but a strong one to make because we were able to acquire this property at about 25% of value, invest some dollars in maintenance and repair to the roof and other sites, all the while marketing it. And some of you may recall that last winter we had a little bit of snow. And right about the time that we were managing that property through the winter and really wondering what the next step was going to be for it, the Maple Vale warehouse in Clymer, a major component of it collapsed. Thankfully, nobody inside of it was killed, but there was a major collapse of that facility, 147 jobs. And as it turned out, Maple Vale was Cisco's biggest competitor in the region. We happen to own the building that used to be owned by Cisco. And we were able to structure a deal, instead of having Maple Vale close, privately owned, nice long-term family. They could have netted out their insurance proceeds. They didn't have to expand. The principal owner has since died. He knew he had cancer at the time. The father was ill, but the family entertained our interest in renting or making this Cisco facility available for them to transfer their business. So within a matter of weeks, we were able to make this deal come together where Maple Vale moved out of their facility in Clymer, moved their 147 workers, and it was Christmas time. And why do I remember that? Because a good friend of mine, Mark Humes, who works for Maple Vale, was standing at the door dressed as Santa, handing out welcome notices and gift certificates to those coming in the door, or candy canes, as opposed to pink slips. And the owners of the facility told me flat out, they said, if we had not been able to make this move to this building with the help of the county, there have been 147 pink slips being handed out by somebody other than Santa that day, as opposed to the candy canes. And why is that important? Once again, we were able to take a significant but appropriate risk. We had that facility available, and basically in a 24-hour period, I happen to know the guy who had to do it. Pat was summoned from Clymer to Faulkner and said, Pat, your job is to remove or cover over every place in this building that says Cisco. So they went out and they had big signs made, tacked them all over the building. They put stickers over everything that said Cisco, and in a matter of days, we're up and running right there in Maple Vale. And at the same time, we were negotiating with a gentleman who is, his business is MVP, and he wanted to bring a major development to that facility, and we were able to structure a deal where he acquired the building. He then sold a portion of the building to Maple Vale, locked in their ownership and the growth and development in that, and at the same time preserve enough of that $300,000 that we were continuing to work with the owner of the building to bring the potential for 100 new jobs into just a portion of that building while securing the Maple Vale piece. That's a role I think is important for government to play. Those are roles where I think professionals operating in roles within the public sector could be essential to helping you do that. If you have any questions on the Maple Vale deal, I didn't see Tom Flowers when I walked in. I'm not sure if he's here. Tom was a local lawyer on that deal, and I believe did his client a significant favor by coordinating with us and helping make that deal come together. But let's get right down to it. How can the county, through the IDEA, bring more money to your deals to help you close more deals? I'll walk through a series of what we have, and they are located in your materials under slide B, I believe. But anyway, I won't delay. I'll just dive right into them. What Chautauqua County has that most counties would love to have is the Alltech Revolving Loan Fund, generated from the Allegheny-Ludnum deal that they were able to reinvest dollars here. We have access and are currently loaning a $12 million loan fund to folks here in Chautauqua County. We can loan up to $1 million. It's a 4% fixed interest, and we can loan that up to 20 years. And that is significant. That's returning $180,000 of principal and interest to our loan fund that we are aggressively out there loaning. When I came into office, there was actually $3 million more that was available in that, but we were advised that that money was being taken back by the federal government because the loan fund was not being used. It was not being loaned. So that $3 million exited Chautauqua County, and the balance of the loan fund was on its way out. So one of the major tasks that our economic development professionals had, Bill Daly, Rich Dixon, and their team at the IDA, was to make that a viable loan fund, make it loanable. So we got local business and financial professionals on the committee. We took back from Philadelphia the management and distribution of those dollars, and right now I think we've got $750,000 of that $12 million left to loan, but at the same time we've got $180,000 coming in each month. We also have a Chautauqua revolving loan fund of $750,000. We loan up to $75,000 per loan. That can be a little more risky. Our standard process is that we want the banks to be in first at 50%. We can come in at 40%, but we need 10% equity from your clients. So you can see how that can be some pretty aggressive lending as a package for those that are trying to bring large or small deals, because the Chautauqua revolving loan fund, we can loan up to $75,000. Many of them are in the $10,000 range. The other ones are some of the sweeteners we can bring to the deal. The tax lease and pilots, the uniform tax exempt policies are part of your materials right there. If you want to know how these work, advise your clients on how best to use them. They're part of your materials right there. We do pilots. As we described in the one deal, we abate sales tax. As we described in the other deal, we also abate the mortgage recording tax. We also have two other unique opportunities. We can issue industrial tax-free and taxable industrial revenue bonds. So when you're talking to your financial professionals, that's something we can do. We've also created a capital resource corporation where we can issue tax-free bonds for not-for-profit corporations. We had a very successful transaction with WCA Hospital, where we took a very complex portfolio that they had, brought that together, and were able to negotiate with them to bring all of their assets into one pool and loan against a portion of that, which leaves a significant portion of their assets available to go out and secure other lending. Previously, as many of your clients have done over the years, they've taken this particular asset and they've used it as security on one deal. And they've taken another piece of their assets and they've used it for security on another deal. And in the end, they've got a management nightmare for the business and financial professionals, but they also limit their capacity to acquire other funding, and also sometimes are paying more interest and more fees than they really ought to. If you have not-for-profit corporations that you represent or organizations, I'll just highlight this Capital Resource Corporation can do these things, has been very successful there, and we've had others that have looked at that as well. I think I've been successful in getting you the half hour you need, but I'd be more than happy and honestly more pleased to answer some questions. And you might want to wonder, Greg, did you ever play basketball in college? And I can say that I did. That certainly was not my best sport by any stretch of the imagination. And I know that to be true because I got a chance to play with Byron. And anybody who's done business with Byron knows Byron. He's a pretty sizable guy. He could play. And what's even more interesting for me, Byron, as you recall, you weren't the biggest guy in the team either. And so all I had to do was successfully get the ball over half court and get to one of these big guys that would take care of things going forward. The good news was we did well. With Byron's senior year, two other guys about the same size, myself and my friend Scott, those who went to Allegheny, Kelso. The problem was they were relying on me and my friend Scott to get the ball over half court. So in the finals, the Fijis successfully prevented us from doing that more than maybe 3 or 4 times the whole game. They crushed us in the finals, but Byron, you carried us all the rest of the way, so thank you very much. I'd be glad to answer any questions that you might have about deals. What's your takeaway? Please, get us involved early. The earlier you get us involved, the better off you'll be. Let me give you one horror story of many. We're not brought in early to the deal. The client goes out and contracts for millions of dollars of assets, business equipment they're bringing to their new development. And it isn't until somebody connects with the county, they come and they sit down and meet with us and saying, well, what can you guys do for us? It wasn't until then we discovered that they had already signed the contracts to acquire all of the equipment going into this, and as a result, about half our capacity to bring leverage to their deal, save them significant money, was missed. Because many, in fact, most all of the state dollars are on the but-for portfolio. They won't come in, they won't provide these significant incentives unless they can be, the sentence goes, but for the involvement of the state, this acquisition or development wouldn't have happened. If you've already signed the contract, if your clients have already signed the contract to acquire, to build, to commit, that eliminates that but-for analysis. So if you're thinking about this, encourage your clients to work more closely with their attorney, more closely with their local finance people on the front end, and we can provide more help to you. Thank you very much. I appreciate it.
By the way, the Greg Edwards comment on the 5 games, they immediately went on a double secret probation.
Well, now, one of the things in the point guard had been much different, and the Fijis might not have celebrated so hard that they wouldn't have ended up on double secret probation. So, George, thanks. Judge, thank you.
Good morning. I was about to say exactly that same thing, Greg. I didn't get to play with Byron, but I have seen both Judge Cass and Greg play, and although they're bigger and stronger and better looking, got many more women than I did at Allegheny, I was clearly a better basketball player than those gentlemen. You know, when you come to things like this, I personally become very grateful. I'm very grateful to Greg Peterson and what he does for this community, and Randy Sweeney and the Community Foundation and the rest of the people that put this together. I see all the sponsors here. It's an incredible opportunity, and we have to be very grateful to have that. And I'd like to thank Greg for putting this together. But also, you know, Steve Cass and I were just sitting there while Greg was talking, and something just came over us, and he whispered in my ear, and he said exactly what I was thinking, which was, my God, Greg Edwards is really competent. And I can't tell you how grateful this county should be when you see things like SKF and Remtronics and Maple Vale, and you think to yourself, those could be businesses that left the area. And through his work and Bill Daly's work and the rest of the county's work, those people stay in our community. I'm very grateful to Greg, and on behalf of the rest of the county, we should go to sleep at night, be very grateful to Greg and his group, and I think he deserves a round of applause for the work that he's doing for this county. Now, when Greg contacted me and said, look, you're from Allegheny, you must speak. There's not a whole lot to talk about workers' compensation unless you do it. But before I get there, I do have to say one other thing. For those who are here from Allegheny, I'm very grateful for the years that I spent there, mostly because I got to be close friends with Steve Cass and Greg Edwards and some of the others. But quite frankly, I hit the lottery when I went to Allegheny, because back then I had a big afro and a beard, and somehow I convinced my beautiful wife to marry me. And she was an Allegheny grad, and that's the best thing that in my mind, happened to me at Allegheny. She was smarter, she was more creative, more talented, and hopefully later you'll see her here today, because she's also going to take some photographs of the event. But despite my afro and my beard, I think that was probably the best lawyering that I ever did, was to convince her to marry me. You have a packet in front of you today, and I put together what's in the materials there is exactly what I hand my new clients when they come into our office. And when Greg said, we want you to speak on workers' compensation, I thought, well, what in the world am I going to tell most of you here, those of you who are attorneys and those of you who are just in the business practice. And my thought was, I'm just going to part a few things, and I'm certainly not going to take all of your time this morning, but I'm going to tell you a few things that you need to know as just a general practitioner. The reason I say that is because I've been practicing this community for 21 years, and you constantly get the phone calls from clients asking you about areas of law that you just don't do. And yet they want the answer right then and there. They want the answer when you're sitting at a Christmas party or a Thanksgiving party or something like that. So I thought, for what it's worth, that I'll spend a few minutes and give you some general basics. But if I had to give you one piece of advice, and this will be my take as Greg talks about, when you get done, the best thing that you can do is refer him to George. because this is what I do. This is the area of law that I've decided to concentrate on. And you can answer some of those questions, but much like the real estate client that came to my office 3 months ago, and I decided, well, he's a good client, let me go try to help him out. Invariably, that real estate deal goes bad. Invariably, there are things that you didn't contemplate. So the best thing that I can do is refer that other business to you people, okay? So in the materials, you have to sort of understand how workers' compensation started. Workers' compensation started because people were getting injured at work, and they had no recourse. So their only recourse was to sue their employer. And so in the early 1900s, that's what was happening. Employees were suing their employers because they were injured. And they were saying, you caused my injury, therefore you should pay me my medical benefits, my lost wages, etc. The state of New York came in because what they were concerned about is employers were sitting there then and saying, you're suing me, you're fired. And there was no protection for these workers from being fired from these lawsuits. So the state of New York stepped in, and they were one of the first states to do it. And they came in and they said, we're going to create a law. And basically it was a no-fault law before no-fault insurance existed. Workers' compensation is a no-fault law. And the provision basically is this. If you're an employer of the state of New York, you must carry workers' compensation insurance. You must pay for it, and you must cover all your employees. In exchange for that, an employee cannot sue his employer. So you're going to get those phone calls. Regardless of how the injury happened, an employee cannot sue their employer. Cannot sue their employer, they cannot sue their fellow employees. And that's the inquiry that everyone has, because, you know, in today's day of marketing and television commercials, the first thing that all these people want to know is, I got hurt, I want to sue my employer. Well, you have to explain to them that there is a complete umbrella against anyone from the employer, employees, corporate entities. There's no way you can sue the employer. In exchange for that, the way the system is supposed to work is those workers are supposed to get their benefits immediately. Timely and immediately. What are they entitled to? In a workers' compensation case, basically you are entitled to three things. You are entitled to all necessary medical care related to that injury for the rest of your life. As long as your medical treatment is related to that injury, you are covered for that treatment for the rest of your life. There's two warnings. One, you have to stay in New York State for treatment. If you go outside of New York State for treatment without authorization, it won't be covered. And secondly, anything that costs more than $1,000 has to be pre-approved. So you can't just go have knee surgery or shoulder surgery without prior approval from the comp carrier. Second thing you're entitled to is lost wages. And the way that works is very simple. They take the day you got hurt and they go back 52 weeks. They calculate your wages for the 52 weeks beforehand, and they develop an average weekly wage. The law says that when you're totally disabled from work, you're entitled to 2/3 of that wage. If you're partially disabled from work, you're entitled to a smaller portion of that wage. That wage stays with you for the rest of your case. So once they establish that average weekly wage, if you ever have an injury or ever have lost time related to that injury, that wage stays the same. To give you an example, I represented a gentleman who worked as a stock boy at Quality Markets when Quality was here, and he hurt his knee. And at the time, he made $150 per week. And so when he missed his 6 weeks of work because of his knee injury, he got 2/3 of that. So 2/3 of $150 was $100. And for those 6 weeks, he was paid $100, $100, $100, $100 for those 6 weeks. He then got his bachelor's degree in engineering. He got a master's degree in engineering from RIT. He now works up at Kodak. And he called me a handful of years ago and said, George, I hurt my knee again. It's still bothering me, and the doctor wants to do surgery. And I said, well, go. Your medical coverage is covered. You're covered for the rest of your life. So we went to see the doctor, and lo and behold, he needed surgery again, and he was covered for all of his surgical care. And he missed 8 weeks of work. Now, at the time, he made $52,000 a year. He made $1,000 a week. And what did he get paid? 100, 100, because they go back to that average weekly wage. The state of New York has never put in any type of cost of living increase. I will tell you at the end of my discussion here what the state of New York has recently done and what they've done to our good, hard workers of the state. But so you're entitled to your medical care. You're entitled to lost wages. And the third thing you're entitled to is permanency. And this is the part that everybody misunderstands. So I'm going to take a couple minutes and explain it to you. The state of New York says that each part of your body is worth a different amount of money. Your pinky finger is worth 15 weeks of pay. If you get that finger amputated, you get 15 weeks of workers' compensation pay. Your ring finger is worth 25 weeks. 30 weeks, 46 weeks. Your thumb is worth 75 weeks of pay. If you were to get your thumb amputated, you would get 75 weeks of workers' compensation pay. Your hand is worth 244. Your arm is worth 312. Your foot is worth 205. Your leg is worth 288. Your hearing is worth 150. Your eye is worth 90. Your big toe is worth 38 weeks. Your little toe is worth 16 weeks. I swear to God, I'm not making that up. And so what happens in some instances is that if you hurt that part of your body and you miss a certain amount of time from work, what they do is, at the end of your case, when they determine how much permanent damage you have to your arm, you will then be entitled to that permanency minus the money you've already received. Now, if you missed a lot of time from work, you may have an injury and not be entitled to any additional money. I'll tell you a very quick story. I represented two brothers. They both got hurt exactly the same day at the same exact accident. They were working laying some pipeline, and a bucket truck tipped over. The two brothers were running to avoid the bucket truck. The one ran, and he twisted his knee, and he hurt his knee. The other brother, the bucket truck landed on him and injured his hand. In fact, the bucket truck couldn't be removed for a while, and he ended up having to have his thumb amputated. For those of you who have ever dealt with people who've had their thumbs amputated, the doctors will want to put an opposing digit on that side of the hand. So either they'll move his finger, move your forefinger over, or they'll take your toe and they'll put it on the opposite side. So you have an opposing digit so that you can grab items. That gentleman missed 83 weeks of work. Now his brother hurt his knee. He had knee surgery. And he was about to miss 10 weeks of work, but instead of missing the 10 weeks of work, when he went into work to give a slip, they said, geez, you're pretty good at that computer-assisted drawing. Why don't you come into work and work on the computer? So he came into work, and for his 10 weeks, he never missed any time from work. A year from the time of their injury, the permanency hearing was held, and I took the first brother in who hurt his knee, and he was entitled to a 10% permanent loss of his leg, which means he was entitled to 28 weeks of pay, minus what he had already received, which was zero. So that gentleman received $11,520. And he said, my God, George, you're the greatest. I didn't miss any time from work, and you got me $11,000. And I had him wait in the waiting room, and then his brother came in. And his brother had his thumb amputated. But his thumb is only worth 75 weeks. And he had missed 83 weeks of work. And when we got done with his case, what did his brother get? Zero. Because he had already been paid for the permanent damage that he's received. It's not that I was a genius in the first case and I was an idiot in the second case. It's all depending on the amount of lost wages they receive. That's what your clients are going to miss. Because all they're going to know is, my brother-in-law hurt his knee and he got $5,000. My sister-in-law hurt her shoulder, she got $12,000. It has nothing to do with what part of their body was or what attorney they had. It depends on how much permanency they have and how much lost wages they had during that time frame. So the best thing that you can do in that circumstance is, as I said, when you have those questions, you're probably not going to know that your big toe is worth 38 weeks or your shoulder is worth 312 weeks. The best thing you should do is give me a call, and I'll talk to your client and ease their pain and explain the situation to them, just to make their life a little bit easier so they understand that. The second type of permanency award there is a permanency for your entire body, and that's called a classification. And a classification is when you have an impairment of your entire body and it keeps you from returning to work. Now, the problem with that is, up until a couple of years ago, if you hurt your spine, your internal organs, or anything that incapacitates your entire body, you could get ongoing workers' compensation benefits for the rest of your life. And that was good. These poor people were hurt, they couldn't go back to work, and so they were able to get benefits for the rest of their life. However, recently there's been a change in the workers' compensation law. And in 2007, the state of New York changed the workers' compensation law, and there was a meeting of all the labor representatives and the business representatives, and they changed the law. And one part of it is very good. The good part is they increased workers' compensation rates. So from 1990 till 2007, for 17 years, there was no cost of living increase, and there was no increase in the maximum rate. The maximum rate in workers' compensation was $400. So if you made $600, you received $400, two-thirds of it. If you made $601, $400. You made $700 a week, $400. If you made $1,000 a week, $400. If you're Bill Gates and you make $5 million a week, what do you get in New York? $400. They changed that as of 2007. They increased those rates. And they changed it from $400 to $500, the next year to $550, the next year to $600. Today, the current rate is $739.89. That's the new maximum comp rate. The problem is, to get that deal, they basically changed this workers' compensation process and said, we're going to put a cap on permanent awards. We're going to put a cap on the amount of permanency that you can have. So you can have an industrial accident and never return to work, and your benefits are going to be capped. You're only going to get 3 years worth of pay or 5 years worth of pay or 7 years worth of pay. So I have to go and explain to clients why their brother, who had 3 back surgeries and is getting benefits forever because his injury took place in January of 2007, and my client, who got hurt in July of 2007, now had their benefits stopped because of this cap. And personally, and this has nothing to do with the Jackson Center or anyone else, this is my personal view. I think that the workers of the state of New York, and specifically the workers in Chautauqua County, got the bad end of this deal. The reason I say that is because we don't have a ton of people making $1,500 a week, okay? We have guys working at Wilson Farms. We have people working at SKF. We have people working at Remtronics who aren't making huge numbers. So they didn't get the benefit of the deal. They didn't get the benefit of getting the higher comp rate, and in exchange, their comp benefits stop forever. And in addition to that, and what's come more to my attention in the last year or so, is the second change, which is basically the state of New York came in and they've decided to become, in my opinion, a managed care state on medical care. And what they've done is they've decided we're going to tell the doctors how to practice medicine. And there is a big, thick book, twice as thick as this, that says, this is what the doctors must do. If you have a shoulder injury, you must do A, B, and then C. If you have a back injury, you must do X, Y, and then Z. If you have a knee injury, you must do 1, 2, and then 3. And if the doctors don't follow that, then none of their bills get paid. They've eliminated certain types of surgeries. They've eliminated certain types of maintenance care that allow people to continue to work. For instance, in New York State, you get exactly 12 chiropractic visits. If you need more than 12 chiropractic visits, you don't get it, unless you ask for super special permission from the state of New York. Okay? That's what I'm going to call it, super special permission. You get 12 physical therapy visits. And if you need more than 12 physical therapy visits, you don't get it, unless you get this super special permission. And the process to get that permission is so arduous and so difficult that I've had doctors and chiropractors and therapists come to me and say, George, we're not going to do workers' compensation anymore, because they made the process impossible for those doctors. Because their theory is that these people are getting too much medical care. And I have a different opinion. If you're telling me that that worker is going to continue to work, that worker is going to continue to be productive, but yet they need to go to the chiropractor twice a week, why in the world wouldn't we do that? So instead, these people are now missing time from work, being less productive in the workplace, because some insurance company wants to go save some money on the number of chiropractic visits they have. So I personally, and that's my own personal opinion, I think that the deal that was struck to increase that maximum rate was a bad deal for the state of New York, and I think it was a bad deal for the workers specifically in Chautauqua County. Since then, there have been some other changes, and this is the one that's most important to me, because most of you probably get this phone call. You know, I get a call for a real estate case, and I'm going, well, I don't do that, so I refer it out. I get a call for a divorce, and I don't do that, so I refer it out. But most of you in this room get a call for someone who had a car accident case or a slip and fall and they got an injury, and you don't refer that out because it's a personal injury case and there's some money in that case. So each of you probably take that case. And you muddle through, you talk to the insurance company, you try to work it out. If you have to try it, you try it. If you have to refer it out at the time of trial, you do that. But what most of you probably miss, and I can tell you it happens every day, because I get calls every single day from the Buffalo firms, from the ones that advertise that are just incompetent in this area of the law, which is they don't know the interplay of workers' compensation and a personal injury case. See, if you get hurt at work, you automatically have a comp case. But you may also have a third-party case. You may also be able to sue somebody else. So if I'm delivering pizza for Pizza Hut, and someone goes through a red light and hits me, I have a comp case, but I can also sue that other driver for the personal injury case. But what you have to understand is that at the time that you go settle that personal injury case, there are three concerns that must take place. One, there would be a lien. And that workers' compensation insurance company has a lien. They're going to have their hand out and say, I want my money back, because I wouldn't have had to pay that lawsuit if it wasn't for that other party's negligence. So the first thing you have to do is you have to make sure you protect that workers' compensation carrier's lien. Secondly, you must get consent. You cannot settle a third-party case without the consent of the workers' compensation carrier. If you do that, then that person's workers' compensation benefits are extinguished for the rest of their life. So if I sit here and I'm handling the personal injury case, and there's a $50,000 policy, and they offer me the $50,000 policy, it's real easy to say, well, good, they offered the whole policy, the other person is indigent, or the other person is judgment-proof, so let's go take that settlement. You can't. You can't without at least going to the comp carrier and resolving that lien and getting them to consent to it. And even if you did that, there's a second thing you have to pay attention to, and this is the part that everybody misses, which is once that person gets their recovery from that personal injury case, the workers' compensation carrier has a credit, which means they have a holiday. They don't have to pay any more workers' compensation until all that money's been spent towards the workers' compensation case. So in the example that I tried to give you, if the case was settled for $50,000 and that person put in their pocket, after attorney's fees and expenses, put in their pocket $30,000, then the workers' compensation carrier can sit there and do nothing and not pay that person's medical care, not pay that person's lost wages, not pay anything related to that comp case until that money is spent towards their workers' compensation claim. And so that's the calls that I get. I get the calls from the disgruntled person who says, well, I settled my case, and my attorney got me some money, but now my comp's ended. And that's something we have an obligation to our clients to explain that to them and their families so they understand and they can make arrangements on how they're going to go forward. And in some instances, settling that personal injury case may not be in their best interest. In some instances, you'd rather take that entire money and give it back to the comp carrier so that that person can continue to get their medical care and their lost wages, etc. And most importantly, there's been a recent change in the case is called Burns. And those who do workers' compensation, the Burns case is a seminal case, and it's something that just recently happened, which is a crafty attorney in Syracuse came in and said, well, because this injured worker had to pay 1/3 of his personal injury money to their attorney, shouldn't that comp carrier have to pay for those litigation costs? And they've changed what's happened now. So instead of the carrier taking a complete holiday, instead of them sitting there and saying, no, we don't have to pay anything, they do have to pay. Yes, they get their lien money back. Yes, they're entitled to a credit. But while that credit is running, the worker still gets 33 1/3% or 35% or 40% of their ongoing medical care and lost wages. The problem is that none of those workers get that unless it's negotiated at the time of the settlement, before the case gets settled, before the client gets their money. If it isn't specifically articulated that the worker is going to retain their Burns rights, that worker doesn't get it. So unless it's in your correspondence, unless it's in your consent letter, that worker is not going to get their ongoing benefits without you putting it in writing and without it getting court approval. So for those of you who do handle personal injury cases, if you do a lot of them, you probably already know what I'm telling you. But for those general practitioners out there that just handle one here and one there, I beg of you, at the time that the case is about to get settled, pick up the phone. I'll drive to your office. I'll have a cup of coffee with you, and we'll walk through the details, because the worst thing that can happen is that you settle that case without protecting all of the client's lien rights, credit rights, and their burn rights. Okay. The other issue that comes up all the time is Social Security and how it applies to workers' compensation. A person may be entitled to both workers' compensation and Social Security benefits. What you need to understand, though, is there is a cap when you add the two of them together. And so in most instances, if a person's workers' compensation goes up, their Social Security will go down, and likewise, if their workers' compensation goes down, their Social Security benefits will go up. The devil is always in those details. The devil should be in you identifying that. What I always do is I get a release from every client, and I contact Social Security, and I get the specifics behind all those numbers. Because in some instances, I might be able to work with the insurance company and work something out on the person's medical care, work something out on their lost wages, because I know that they're going to get the same benefits from the Social Security system. I feel very fortunate to be able to do what I do. I had the opportunity coming out of law school and to go to a number of different communities. I'm very grateful to come to this community, and I'm, as crazy as it sounds, I'm grateful to practice the type of law that I practice, because I get to see 800 to 1,000 hardworking people every single day who, in my opinion, because of this system and because of the flaws in the system, are getting screwed. So I have the opportunity to come and help those people. What we as practitioners need to do is answer the questions that we can, but the ones we don't, make sure we get them to someone who's competent. I know that I can't do a divorce case. I know I can't do a tax case. I know I can't do a matrimonial case. I certainly know I can't do competent real estate work. What I'm going to ask you to do is give them some general answers, ease their pain. These people are hardworking people who got injured due to no fault of their own. Ease their pain, and then get them to somebody, whether it's myself or a number of the other attorneys that practice in this area. Get them to someone who can help them, because it's, there's nothing worse than seeing a family who can't pay for the kids' school clothes, who can't get the treatment they need because some insurance adjuster sitting in their office in Albany or in New York City or in Chicago and wants to nickel and dime them over benefits. So the best thing that you can do is get them to someone who can help with their situation. Thank you very much for your time. Is there any questions? Anyone have any questions about the workers' compensation system? Thank you for your time.
Byron Blakey, superstar. Obviously, you were the power forward.
I think Greg's words were very kind. I think he over-exaggerated. Time has we're getting old enough where time, I think, maybe you have more generous memories of your friends and colleagues. But I think he overstated my abilities on the basketball court. Well, it's truly a privilege to speak at the Jackson Center, particularly being a part of a panel with such distinguished lawyers, judges, elected officials, and most importantly, friends. And actually to, as well as, of course, the management team of the Buffalo Sabres, and Ted Black in particular. But it's also a thrill to speak in front of such a sophisticated and attentive crowd. And I'm very excited to talk to you a little bit today about intellectual property issues. So when Greg, these are exciting times, believe it or not. I don't know how aware you might be. But on the national level, there's been some breathtaking changes that have occurred in the area of patent law in particular, with the American Invents Act, which President Obama just signed into law, which I was at a conference in Washington where there were about 1,000 intellectual property lawyers, and they were characterizing those changes as the most sweeping changes in patent law since Thomas Jefferson was a patent examiner. So how many of you knew that Thomas Jefferson was the first patent examiner in the United States? There's a bit of trivia, Greg, here. But I suppose I would agree, and I'll cut you a break, that the authoring the Declaration of Independence probably is probably a greater feat than his being a patent examiner. But as I explained this to Greg over the phone when I called him, like George, and said, IP is as deep as it is broad, Greg, what do you want me to talk about? And so Greg said, Byron, two things. One, you're a warm-up act for Ted and the Sabres. And two, keep it light. So Greg, I took those words to heart, and I hope you don't regret saying them to me. So with that, I retired to my study at my house that evening, which my wife calls the man cave. And I decided first I'll have one of my favorite beverages because I got to figure out what I want to talk about. So as I was thinking that through, I first had to think, well, I could reprieve a presentation that I gave on trademark law to another professional NHL hockey team, which shall remain nameless. Wait a minute here. How did that slide get in there? I'm not quite sure. My paralegal, who's been with me for about, 10 years, Jen? 12 years, forgive me, is normally very good, and I can't imagine how that slide slipped in there, other than the fact that Jen Close is Ted Black's sister. So I'd like to introduce Jen Close, paralegal in our firm. So I'm sitting in my study, and I'm thinking, first, well, let's reflect on the venue. This is a tremendous venue, and in the Jackson Center, of course, the legacy is to honor Justice Robert H. Jackson, who thanks to there we go, and thanks to the great work of the Jackson Center, we all now know that Justice Jackson was quite a stud. In addition to being a New Deal lawyer, he was Associate Justice of the United States Supreme Court and a chief prosecutor at Nuremberg, where he stood toe-to-toe with the most notorious war criminals of the 20th century and put them in jail, prosecuted them, put them in jail, and worse. So at that point in time, I'm thinking, okay, we have a great venue, we have a hometown hero, we have intellectual property law. I don't know how I'm going to weave that together. So my son comes into the room by chance, and he's an aspiring filmmaker applying to college. And my wife and I laugh to have this kind of confidence at 18. I wish I did at that point in time when I was going to Allegheny, but I didn't. He thinks he's going to win an Academy Award for film directing. So with that as my final inspiration, I've come up with the working title for the presentation. And welcome everybody to the 2011 Jackson Center IP Awards. Now, Greg, did you notice the head of Justice Jackson on the Oscar there? We thought that was a nice touch. Okay. So, for such a coveted award, we're going to present this award today for the best IP case of 2011, of course, to discuss over cocktails at the Jackson Center. And so let's, without further ado, meet the nominees. The first case is out of the Southern District of New York, and it's Louboutin v. Yves Saint Laurent. It's a trademark case. Our second nominee is In Re Chippendales. That's also a trademark case out of the Court of Appeals for the Federal Circuit in Washington, recent, as well as Louboutin this year. The third case is Levi Strauss v. Abercrombie and Fitch. That's out of the Ninth Circuit this year. And of course, no conference, no CLE lecture on IP, or frankly any other matter, would be complete without a case from the very entertaining Ninth Circuit Court of Appeals. And the last case is Harney v. Sony Pictures out of the District Court of Massachusetts. So my staff labored hours over selecting these nominees, and it was hard fought, and the lawyers in the office debated hours over which cases to include, but ultimately we came to these cases. The honorable mentions and some of the patent cases that were very interesting this year are included in my paper, along with some additional trademark cases. So if you're interested, you can look through the paper. So without further ado, let's meet these nominees up close and personal. So first is Louboutin, and we need to dim the lights.
Ladies and gentlemen, the fabulous Jennifer Lopez.
Hello, Santa?
And what would you like for Christmas, little girl?
I would like a shiny new pair of Louboutin shoes. You know, the ones with the high heels and the red bottoms?
And have you been a good girl?
Yes, I've been a very good girl, but he's been a very, very bad boy.
Lights. What were we talking about? Should we just award the Jackson and I can sit down now? But Greg informs me we were getting CLE, so he's asking me to press forward. Now, actually, I could see some of the women in the audience, and I acknowledge nodding up and down, and I played that video for the men who might be a bit fashion challenged, as I am with respect to women's fashion, and so that was for your benefit. Just to make sure that, that I'm not accused of pandering just to the men, we'll have another video clip shortly. So the issue in Louboutin, what was the issue in Louboutin? Whether Louboutin can enjoin, it was a preliminary injunction case, the sale of Yves Saint Laurent shoes in the view of Louboutin's registered mark to the red sole mark. So thanks to Jennifer Lopez, we know what that mark is. The holding, Louboutin's motion was denied, okay? Now, it was a preliminary injunction, so the court could have gone off on irreparable harm and those kinds of things, and those of us who have tried preliminary injunction cases know that that's a pretty high threshold to prove a preliminary injunction. But this court didn't do that. This court went off on a completely different route or tangent, and indeed went off on the issue of functionality. So what is trademark functionality in terms of color? A red sole shoe mark. Color alone sometimes may be protectable as a trademark, quoting the court, where the color has attained secondary meaning and therefore identifies and distinguishes a particular brand and thus indicating its source. Now, the court went on, and it's really a remarkable decision. I commend it to you. I should have included it in the materials, but you'll be able to find it with a citation. It's a 31-page opinion by one of the judges on the district court, the Southern District of New York, and it's replete with several rhetorical flourishes, including references to Walt Whitman and a hypothetical that the court came up with between, believe it or not, Monet and Picasso. And indeed, the court quoted from Jennifer Lopez's song, which I just began to play the beginning part of it. So the judge was really into the case, as we like to say. What also the judge interestingly acknowledged right away in his opinion is that everybody in the know, the cognoscente, the Hollywood elite who can afford $1,000 a pair for a Louboutin, like Jennifer Lopez, know immediately the source of those goods because of the red sole and the source of those goods being Louboutin. So the court acknowledged that right at the beginning, but in an interesting twist, says that fashion is completely different than industry in regular manufactured goods. So fashion and apparel stand alone. So it went into the bizarro world, if you will, and said that, first stated as a matter of general law that color may not be protectable when it is functional. That's true. However, the court went on and where it turned the functionality doctrine on its head, said that the doctrine forbids the use of a product's features as a trademark, where doing so will put a competitor at a significant disadvantage because the feature is essential to the use or purpose of the article or affects the cost or quality. Well, here, indeed, putting a red lacquer, this Chinese red as it's known, clearly increases the cost of the product, and that normally mitigates against the finding of functionality. In this case, because it's the fashion world, the court said it cuts in favor of functionality. So it really did turn functionality in respect to trademarks on its head. But what's the takeaway from a case like this? Well, my staff had a bit of a different takeaway. They're a group of irreverent lawyers, a bit, very bright, and their takeaway was, beware of judges who watch too much Project Runway. So in deference to the court, to which I'm admitted, my takeaway is the case doesn't apply outside the fashion industry, and my manufacturing clients can breathe the collective sigh of relief. So let's meet our second nominee. Well, I played that for the benefit of women to show that I'm an equal opportunity panderer there. And in particular, what you were to notice were the white cuffs and collars. I don't know, ladies, if you were actually focusing on the white cuffs and collars. But that's what the case is about. And so the issue that the Federal Circuit heard on appeal was whether Chippendales can register the cuffs and collars mark as inherently distinctive. At the Trademark Office, the applicant was denied registration on that basis, and the Board of Patent Appeals and Interferences, I'll strike that, the Trademark Trial and Appeal Board, upheld that holding, and Chippendales appealed to the Federal Circuit. The Federal Circuit held that the board's determination was supported by substantial evidence, unfortunately for Chippendales. But what was the rationale? The court began by stating a relatively black letter principle of the law of trademarks. The test for determining inherent distinctiveness focus on whether or not the trade dress is such a design that a buyer will immediately rely on it to differentiate the product from those of competing manufacturers. However, the caveat to that, there's always a caveat, is that a mere refinement of a well-known form of ornamentation for a particular class of goods fails to meet the test. So what was in play at Chippendales is the court found that the Playboy costume, the bunny costume, of course, was the inspiration for the cuffs and collars mark, and therefore, on that basis, the court denied the registration based upon inherent distinctiveness. And so what could the takeaway be? Well, I guess Playboy rules. So let's meet our third nominee. The third nominee is Levi Strauss, and out of the very entertaining Ninth Circuit Court of Appeals and this year. And so all of us who have teenage sons and daughters are familiar with Abercrombie as they're doing their school shopping. In this case was brought by Levi Strauss in connection with their very famous, as we all know, pocket, which is a little bit hard to see without the lights dimmed. But everybody can appreciate if they have a pair of Levi's, the two connecting arches that meet in the center of the pocket. And the question was that infringed by Abercrombie's what they call the rule design, which you can see in the bottom pretty well. And when you compare the designs, I think, with the rule, you see that the arches are less pronounced, and there's what's called a Abercrombie calls a doodle that is at the center, if you will, of the two connecting arches. So what did the Ninth Circuit hold? On appeal, the Ninth Circuit held that the trial court applied an incorrect legal standard, something that's not done here, of course, but in that district court, the court applied an incorrect legal standard of identical or nearly identical. So the Ninth Circuit said that the trial court, when it was comparing the marks, was holding Levi to an identicality standard or a substantial near identical standard, and that's too high of a burden of proving infringement. The Ninth Circuit had it right, of course. The judgment was reversed with respect to Levi's claim and remanded. And the rationale, well, the rationale is pretty straightforward. Under the Lanham Act only requires the trademark registrant to show that the junior mark, in this case Abercrombie, that came to the marketplace after Levi's, is likely to impair the distinctiveness of a famous mark based upon dilution factors, including the degree of similarity. So it lessened the burden with respect to Levi in view of the fame of its mark. And so I like when cases reveal universal truths, and this one did. Age plus money equals power. And in particular, Levi's use, as I alluded to, dated back to 1873. Abercrombie, came to the marketplace with this very, very recently. And garments with Levi's designs have generated over $50 billion over the last 30 years. So there was not going to be, as we say in the law of dilution, any death by 1,000 cuts. And the Ninth Circuit wasn't going to allow that. Good for them. The last case I have, the last nominee, is a copyright case. So I thought I'd throw a copyright case in there. Copyright purists will say, well, that's just another, comparing the photos. There have been some very important copyright decisions. I don't practice a lot of copyright law, so they're not even in my paper. But this one I thought was interesting because I did catch the TV movie. So here we have a picture on the left of a man with his daughter on his shoulders, and she's holding a palm, a Sunday palm frond. And so this picture was taken on a beautiful sunny day, as it were, in a very Tony section of Boston, Beacon Hill. And a photographer was being asked by his paper to take pictures of the quintessential Beacon Hill experience on a Palm Sunday. So this handsome father and beautiful daughter, a photographer took that picture. Now, what the photographer didn't know, and this is where I think it gets very interesting, what the photographer didn't know is he took a picture of the infamous Clark Rockefeller, which, if you've seen the movie and you've read the news accounts, is an imposter. So his real name is Christian, it's a German name, Gerhard Reiter, Christian Gerhard Reiter. So he's a German citizen. He came to the United States and he thought, well, gee, if I change my name to Rockefeller, or I pose as a Rockefeller, the elite in Boston and Long Island, and will give me money, and in fact they did for a long period of time. However, this was in 2007, and he married a Boston socialite under the name Clark Rockefeller. So he was quite a con artist. And as it turns out, shortly after Harney, the plaintiff in this case, the photographer, took that picture, his marriage to the Boston socialite was crumbling. Those who he had built out of their money, substantial amount of money, were doing some investigation, and the jig was up, as it were. So he kidnaps actually, his daughter, and takes her to several cities throughout the United States. And finally, in fact, the Harney photograph was used by the FBI on wanted posters. So with the help of the copyrighted photo, they found Clark Rockefeller and his daughter as they were about to board a vessel headed for Europe, I think back to Germany. And so luckily, they caught him just as he was about to leave the country, brought him back, and then, of course, his identity was revealed. His daughter was returned safely, thank God. And so you'd think the story might end there, with the exception of maybe some prosecution of Mr. Rockefeller. But it didn't, because why? Well, because this is America. And what happens in America? Well, first, we get a made-for-TV movie. So Sony Pictures makes a movie of this story. And what's the second thing that happens once a movie is made in the United States and we have a copyrighted photo? The photographer, of course, sues Sony Pictures for infringement. So that's the issue before the District Court of Massachusetts, is whether certain images in a Sony made-for-TV movie violate the exclusive rights of the copyrighted photograph of Clark and his daughter Ray Rockefeller. So what did the court hold? Well, Sony was pretty confident that their photograph, which is on the right, which is not a photograph, but it was a frame from their made-for-TV movie, they're very confident that they didn't infringe, so they bring a motion for summary judgment as a matter of law that there's no infringement based upon our record of undisputed fact, and Sony's motion was allowed. And so, interestingly, what did the court do when it compared the copyrighted photo, which indeed the court believed that it was copyrighted material, when confronted with the clip from the made-for-TV movie? Well, the court establishes and lays out in its opinion a very elemental aspect of copyright law. There are two prongs to infringement of a copyright. One, you have to show valid ownership and access to the copyrighted work. And secondly, copying of the constituent elements of the work that are original. So the court engaged in what is commonly known as a dissection of the fact-based aspects of the copyrighted photograph, and it excludes those fact-based elements. So what are the fact-based elements in the photograph on the left? Well, Clark Rockefeller and his daughter aren't actors, so he didn't pose them, he didn't dress them. He caught them as they were coming out of church. So the court held that Clark Rockefeller holding a church program was a factual element. The way they were dressed was a factual element. And even the palm frond was a factual element. But the court also held that there was some substantial creativity with respect to the photo. So it held there was a valid copyright. And what it thought was expressive or creative about the photograph was its overall composition, and particularly its use of light, and the church in the background, and how he centered the two individuals, with the church being visible to the right of the little girl. And of course with a light, and the light's fairly interesting in the photograph. So the court held those elements were copyrightable. So in light of that dissection, Harney must show that the defendants copied his copyrighted material, what we talked about, the expressive elements, and that the copying is extensive enough to render the original and infringing work substantially similar. So in holding for Sony that the copyright was not violated, it looked at the Sony picture and it could see obvious differences relative to the expressive elements. So, of course, I think one of the first things you notice is that the lighting is not the same as in the copyrighted photograph. The composition of the individuals in that photograph is different. It's not quite as centered. Of course, there's no church in the background. And so in light of the fact that there was not a significant, or actually a de minimis copying of the expressive elements, the court held in favor of Sony Pictures. So I guess with the takeaway with that is that Sony had very good advice from their IP lawyers. So with that, I think that I wanted to just keep it short and light as Greg instructed. And with that, I think that we're going to, award the Jackson. And so Jen has the sealed envelope, which has been kept in our safe for the last 48 hours, and it has a seal. And so right here and now, we're going to open it. I have no idea who it is. And the winner of the Jackson is the King's Speech. Nope, wrong one. It's the Louboutin. No surprise, perhaps. And so, with that, enjoy your IP responsibly. and most importantly, go Sabres. Thank you.